Special counsel Robert Mueller and his team have obtained tens of thousands of emails from the Trump transition team, and the president isn't happy about it. Now, lawyers representing the Trump transition accuse Mueller's team of getting unauthorized access to the emails, which a Mueller spokesperson denies. Joining me now, CNN chief legal analyst Jeffrey Toobin and criminal defense attorney Alan Dershowitz. Jeffrey, these emails, the Trump transition lawyers say that the special counsel's access was unauthorized. Mueller's team disagrees, so how do you see it?
I think Mueller's team is right. These were .gov emails. They were government emails. The government doesn't need a subpoena to obtain government emails. The people who were on the transition team were warned explicitly that they had no expectation of privacy in these emails. There was just no reason, legal, prudential, or otherwise, to do differently than what the Mueller team did.
Professor Dershowitz, you say, though, that Mueller's team acted carelessly. How so?
They did. They did. This is a cutting-edge issue that courts are confronting every day and coming out with different resolutions. Whether you can en masse get emails, even if it's in a transition team, which may include some privileged emails, maybe even some lawyer-client emails, there was absolutely no reason for a special prosecutor who may be going after the president not to wear a belt and suspenders and to go and get a warrant. It's the easiest thing in the world to get. Judges give out warrants like Christmas candy. Why not protect yourself from what inevitably is going to be a defense attack? Why give ammunition to the other side if you can so easily avoid this question from even being a plausible one? Look, in the end, Jeffrey may be right, but why take a chance?
Jeffrey, why not?
Because Alan is advocating the Sean Hannity standard, which is do something that Sean Hannity would find okay. That's a fool's game. People are going to criticize Mueller no matter what he does. I think there's a better standard, which is the law. The law is you don't need a subpoena. You don't need a search warrant to get .gov emails. I am unaware of any case where the government needs any special authorization to get government emails. I mean, maybe the law should be different, but I don't think there's any law that is different.
Professor?
First of all, it should be different, and civil libertarians shouldn't be moving to try to see an expansion of this dangerous development. Second of all, I'm not aware of any case where the emails, massive numbers of emails from a transition team, which is quasi-public, quasi-private, sure it's .government, but why take a chance? It's not the Sean Hannity standard. It's the Justice Roberts standard.
Professor?
It's the Justice Alito standard. Make sure you're covered. Make sure that there's no possibility when you're going after the potential of the President of the United States, you take no risks and no chances. You cover yourself in every possible way. And that's not what Sean Hannity wants. He'd much prefer to see the special prosecutor be sloppy. I want to see the special prosecutor be accurate to protect himself from any possible challenge, a challenge that I would make if it were one of my clients.
Well, look, I think Alan is, as always, a principled civil libertarian who has very definite ideas about what the law should be. All I'm saying is that as far as I'm aware, the law is currently that Mueller had the right to do what he did, and I don't see why he has to pretend that the law might be something different down the line when he is simply applying the law as it exists today.
Professor, why would there be any executive privilege here if, by definition, the president-elect is not yet the president, not yet the executive?
Well, isn't that the irony? So the argument on the other side is there's no executive privilege because he's a private citizen. On the other hand, he's a government official for purposes of not getting a warrant. You can't have it both ways. Clearly, anybody in the transition team is in a quasi-public, quasi-private position. There is no case law on this. The last thing you ever, when you're a patient, you never want to hear the doctor say, that's an interesting symptom. And when you're a special prosecutor, you never want to hear a lawyer like me say, that presents an interesting novel issue. You have to avoid novel issues like that.
The employees of the transition weren't quasi-told that their emails are government property. They were directly told by the GSA special counsel, the deputy counsel, that these emails, lived on government servers and were subject to monitoring and that there would be no expectation of privacy. Does that matter here?
No, because, you're told that routinely. I'm told, I guess I'm on the Harvard Law School server, and somewhere in fine print there must be a statement saying Harvard has the right to look into my emails. I don't expect Harvard's going to do that. And I do have a reasonable expectation of privacy if I'm writing to my lawyer, if I'm writing to the future president of the United States, that there might be some privileges that will attach. It is not impossible that a judge may say that transition emails that haven't been vetted for any kind of privilege should have required a warrant, if that's even conceivable.
Jeffrey Toobin, does this end up anywhere legally, or is it just a political argument? Does this just end up in the political sphere?
I think what's most revealing here is that the transition lawyer wrote a letter and released it to the press and made a public stink. What he didn't do is go to court, because he knew he would lose in court. I mean, this
Too
is
early.
part
Too
of
early.
this.
There's no standing. Too early to go to court.
This is part of the offensive against Mueller's legitimacy.
I agree with that.
It's taking very different forms. Some of it is narrowly legal. Some of it is broadly political. Some of it involves the personnel on Mueller's staff. But I don't think anyone should be confused that this is somehow a novel legal issue. It's black letter law. It's not controversial. And it is just another way of mobilizing the Republican base against Mueller and prepare the groundwork for the possibility that the president might arrange for his firing.
Professor Alan Dershowitz, Professor Jeffrey Toobin, thank you so much for being with us, gentlemen.
Thank you.